Hi, good morning, everyone. Welcome to the HR Roundtable. See people filing in. Welcome, welcome. Let me see if I can see who is here so far. All right. Good morning, Angela. Good morning, Annette. Deborah Royal. Good morning. Greg Myers. All right. Good morning, JJ. Shabina Johnson. Good morning. Mr. Lugiadano. All right, we're going to give everyone a little time to get in here, but welcome everyone to the September HR Roundtable meeting. This is our back to school session, right? A little chill in the air this morning. Starting to feel a little bit like fall. All right, we got 63 people in the room. Good morning. Good morning to everyone who's just logging on. Robin Salzberg, good morning. All right, we're going to be starting in a few minutes. We're just going to give people a little time to get in here and get their. Anyone still drinking coffee at 11 besides me? Get their coffee cup.
I am too, Roger. Don't worry.
All right, very good. Very good. It's not just me. We've got a great session for you this morning. We had over 200 registrants, and we'll see how many folks are actually able to join us. We sent out a little last minute reminder to everybody because we all need reminders. All right, looking good. So we are at 75 people online. Good morning, everyone. Welcome to the HR Roundtable. We'll be starting in a couple of minutes. Sharon Greenberg, good morning. All right, very good. We will get started in just a minute. And folks are still coming in. We're at 82 people. Very nice turnout. And not surprising given the topic. This is coming right down the pike, speeding at us, lightning speed. All right, so I think we can get things going here. Good morning, everybody. Welcome to the HR Roundtable, our September edition. We're calling this our back to school edition. Everyone's got kids back to school. We've all back from our travels and time to get serious. Sad, isn't it? I'm going to introduce our speaker in a moment, but first I wanted to introduce my colleague, Brian Bulger of Marsh MMA. Brian and I started the HR Roundtable together years ago with a goal of really arming HR people to the teeth with timely information about topics like these, things that are compliance related, as well as other things that other information that can help HR to really earn its seat at the table with the C-suite and to be viewed as a strategic partner instead of a cost center or any old paradigms that are usually laid upon HR. And always great to meet new people. I think we're going to have a lot of new folks here on the call this morning, and we are up and over 100, which is fantastic. I think I will just give you a little information about, tell you a little bit about temp positions. My name is Roger Oliver, as you can see on the screen here. I'm the Director of Strategic Accounts for temp positions. I've been with the firm for 24 years. I started when I was 12. And just to kind of give you a little window into the organization, it's probably best described as a multifaceted staffing solutions firm. We do temporary, temp to hire, and direct hire across a really wide range of skill categories. So as you can see here, all of the different divisions of temp positions are all branded with a name to reflect that discipline. So account positions for accounting and finance. It's a very, very busy area for us right now. CompuForce for a full range of IT professionals. HR Staffing Solutions is our human resources division. So we provide staff and consultants for all major disciplines of HR. So when you run out of hands and need extra hands, we can help you with that. On-call counsel is our legal division. So we provide contract attorneys, paralegals, legal admins, and other roles. We have a very large education footprint. School professionals is our education division. We do substitute teachers for charter schools and private schools. And we also have an exclusive arrangement with the city to provide pre-K teachers for the New York City UPK program. So all of those community-based organizations that are running pre-K programs funded by the city, when they are not able to find teachers on their own, that redounds to us. We're very proud to be the engine under the hood of the New York City UPK program, largest school system in the country. Our convention services is sort of an offshoot of our hospitality division, but everything geared towards a trade show environment. If any of you are so lucky to participate in trade shows and need assistance with that, hospitality, temp positions, eating hospitality, waiters, bartenders, culinary professionals for all types of events. We have a very, very large healthcare organization and a large footprint in the social service staffing area. We work with a lot of organizations that provide services to people with developmental disabilities, child welfare, shelter programs, and we are also do allied staffing and clinical staffing as well. And we provided staff the Vaccinate New York initiative for the entire state of New York, over 5,000 people throughout the state. You can remember those large pods at Yankee Stadium and the racetracks and Javits Center. We provided staff for all of that. So healthcare is a large area for us. Logistics, for all the hands that go on all those boxes that have been showing up on our doorsteps over the past 2 years or so. I don't know if anyone else suffers from what they call primnesia. You're familiar with primnesia? That's when you order so much stuff from Amazon that you don't remember what boxes show up. You don't remember what's in them. That's the primnesia. And general office staffing needs no explanation. And the Creative Bureau is our creative division, graphic artists for design and production, and all things web. And lastly, is our TGC search division. So we do executive search across a wide range of skill categories there. All right. Welcome, welcome. Look at this, 114 folks here. So this must definitely a topic of interest. So with that, I'm going to introduce our speaker, Maria Papasevastos. I practiced.
No worries, I get it all the time.
Yes, indeed. And Maria represents employers in all areas of employment law, including discrimination, harassment, retaliation, and wage and hour matters, and has experience working on both single plaintiff and class action litigation. Maria also counsels clients on employee policy and procedure development, as well as federal, state, local law compliance. Maria's experienced trial attorney and has successfully litigated trials to verdict on claims including discrimination, hostile work environment, and retaliation. And in addition to her employment law practice, Maria has significant experience in representing developers, institutions, and nonprofit organizations in a variety of New York City land use and zoning matters, including variances, special permits, designations and alterations of landmark buildings, and air rights transactions. And her work in this area also includes representing clients in proceedings before the New York City Planning Commission, Board of Standards and Appeals, and Landmark Preservation Commission. And with that, I am going to turn this over and leave you in the very capable hands of Miss Papasevastos.
Thank you, Roger. Let me pull this up. All right. So yeah, this is a hot topic. We are all seeing it in the news. We are seeing studies being done about how to further pay equity. We're seeing pay transparency as a key focus in the media for employers. And so now we have the New York City law on the horizon. And I think there's a lot of focus on this law from both the employer side, from the government side, and it's an important kind of piece of legislation that's going through. But it's not only New York City, and as we'll kind of go through in this presentation, there's a bunch of other laws across the nation that are following this trend. A quick legal disclaimer: this presentation is prepared by Seyfarth Shah for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. Okay, so as Roger mentioned, I am an employment lawyer. I do a lot of work advising clients on various laws, and my main focus as of late has been on these pay scale disclosure laws and pay transparency generally. There's been a big push in this. So what we're going to cover today is an overview of those pay scale disclosure laws generally, both in New York City as well as other key jurisdictions nationwide. We will do a deep dive into the New York City obligations, so you can feel like you're as ready to go as you can by the November 1st deadline, and comparing the New York City law to other key jurisdictions so that you can determine how to come up with a compliance strategy if you do have operations in other states. I also wanted to touch on paid data reporting. There are paid data reporting requirements currently in effect in Illinois and California. And that seems to potentially be the next trend on the horizon. So I wanted to give you all an update on that and something to look out for as this develops. I will also be covering pay equity and the impacts that these laws are going to have on pay equity in organizations' culture and thinking on pay equity generally, and then key takeaways for employers and HR folks and how to actually comply with these laws and steps that I would suggest that you take as you're thinking about compliance. So a lot to cover.
Yeah,
but
I
looking
just want
forward
to,
to this. Yeah.
Maria, I just wanted to say for if people have questions, please use the Q&A tab down the bottom to pop your questions in, and I will answer them periodically as they come in. But definitely use the Q&A instead of the chat window for your questions. And that way,
yeah, and I'd love to keep this interactive. So as many questions as you have going on, I'm happy to answer them.
Absolutely, I will make sure we get to them all.
Great. All right, so let's jump into the overview of pay scale disclosure requirements. And before we get started on this, I think we had a quick survey question so I could help kind of tailor my presentation to your needs and kind of looking at the different jurisdictions that you might have employees in. So do we have that survey question?
Walter, do you have the survey question for jurisdiction? All right, so yes, do you have employees outside, in states outside of New York? And yes or no, we'll see how this shakes out. All
right, while we're waiting for those results to come in, this list on the screen is current jurisdictions that have pay scale disclosure requirements in place. So the requirements are, they differ greatly by jurisdiction, with kind of three big buckets that we'll go through for how the states and local jurisdictions are approaching these laws. Some big kind of key ones to highlight are Colorado, which has very far-reaching implications and was really the driving force behind these pay scale disclosure laws being within job postings. We have New York, and within New York, there's the New York City law that is going into effect on November 1st. And then there's Ithaca that is currently in effect as of September 1st, and Westchester County, which will go into effect on November 6th. Then we have a state law that is currently, it currently passed the New York State legislation, and it is pending governor action. That one will be going into effect 270 days after it is signed or taken action on by the governor. So that's a big one to watch as well. So I don't think I see oh, there we go. All right, so it seems like we're pretty evenly split with a good amount of folks with employees outside of New York. So I'll make sure to touch on those laws as well as we go through this, because it's certainly a challenge to try to comply with all of them.
And people have, several people have asked about a copy of the presentation. Yes, it will be available as well as the video itself. So you can rewatch this and you can share this with your colleagues as well.
Great. All right. So the first big bucket of these pay transparency laws and pay scale disclosure laws specifically are jurisdictions that require you to provide pay information upon request. And that might be to an applicant applying for a position or to a current employee. I'll note for California that while the current California law is upon request only, and not an affirmative requirement to disclose this information, there's also legislation pending in California, again, before the governor to act on it. And we fully expect that it will be enacted into law. And the California law will require employers to put pay disclosures within job postings as well. So this is just the current state of the law as of this presentation. So this first bucket is companies, states or other jurisdictions that require that if an applicant or an employee, current employee in Washington requests information about their pay scale or wage range, then the company has to provide it upon being asked about it. And again, another caveat about Washington state, that's another one that's being amended, and we'll discuss that in a moment as well. The next bucket of these jurisdictions are those that require an affirmative disclosure of pay scale information. So that is that there's nothing the employee or applicant has to do to prompt it. It's the company that has to affirmatively provide this information at a certain point during the application or during the employment process. So for example, in Connecticut, For applicants, employers have to provide they have to provide pay scale information if the applicant requests it, but also prior to or at the time of an offer of compensation. Now, if the first time that you're offering compensation is in an offer letter, for example, some employers choose to have some kind of template form that's an offer letter where they'll put in that salary range into that letter and have that as kind of your compliance for meeting these requirements. Of course, if you do offer compensation earlier, it has to be provided then. And if the applicant requests it, you need to have a system in place for responding to those requests as well. And for all these laws, what must be provided in terms of the wage range or salary range, that differs as well based on the jurisdiction. So in Connecticut, it specifies that by wage range, it means the range of wages the employer anticipates relying on when setting wages for a position. And it lists certain components that may be referenced in deciding how to set a pay scale. So in Connecticut, for employees, there is a requirement, an affirmative requirement to provide pay scale information upon hire. So again, that might be killing two birds with one stone, where you put it in an offer letter, and that would be providing the information at hire and at the time that you offer compensation. You would also have to provide the information upon a change in the employee's position. So let's say an employee transfers to another position or is promoted, there has to be an affirmative disclosure of the pay scale for that new role for the employee. And again, in Connecticut, it's upon a current employee's request as well. Nevada is another one with one of these affirmative disclosure requirements. For applicants, it's upon completion of an interview for a position. And for current employees, it's for a promotion or transfer to a new position if the employee has applied for the promotion or transfer, completed an interview, and made a request for the information. So for current employees, it's upon request when they transfer positions. For Rhode Island, it is upon request for applicants, and there's language that employers should provide the wage range prior to discussing compensation, but it's not a requirement in Rhode Island. For employees, it is an affirmative obligation to disclose upon hire, and when the employee moves into a new position, and when the employee requests the information. So in Rhode Island, the affirmative disclosure kicks in when you have a current employee. And for Rhode Island, again, there's definitions of what it means by wage range, with the wage range meaning what the employer anticipates relying on in setting wages for the position, and it could include reference to these factors in determining the wage range. So the next big push in these laws has been to require a disclosure on the job posting. Now, this really started with Colorado having pretty far-reaching implications for employers. So I'll start with that one, with Colorado. And Colorado requires employers to disclose compensation information in the job posting, as well as a general description of any other types of compensation, as well as a general description of all employment benefits that are being offered for the position. Now, Colorado has this added component of a promotional opportunity notice requirement. And that means that every time there is a position that could be a promotion for one of your Colorado employees, you need to provide notice of that promotional opportunity to the Colorado folks. And promotional opportunity is very broadly defined under the law, where it could be any position that would be any kind of increase in opportunity or salary or benefits. And it's not only if an employee is qualified for the position. It is, so if you have a a worker in Colorado who is in accounting, and then you have a legal position within New York, and let's say that would be a career advancement for the employee, and it would be a better paid position or provide more opportunities for that employee, then the employer would have to disclose that legal position to your accounting professional within Colorado. There's also a record retention requirement within Colorado, and we can kind of cover this a bit more later in the presentation if it's of interest. So California, one more thing I'll note on Colorado is that the law is broadly defined to apply to all positions that are performed in Colorado, but also positions that could be performed remotely from Colorado. So if you have a job posting and it's for a remote position that can be performed anywhere in the United States, then you would have to provide notice of that promotional opportunity to your Colorado folks and include compensation information within that job, within that notice. And any job posting that's provided would also have to include that compensation information if the position could be performed in Colorado. So,
Maria, I have a question here from a participant asking for Connecticut. When informing the candidate of the compensation for the position offered, I guess the question is, does the employer have to provide the pay scale or range of wages and the actual salary offered? I believe is a question.
Yes, that's so. If you're providing it in like an offer letter, then yes, you would provide the actual compensation that you're offering the employee, and then you would provide the pay scale for the position that is being offered. So, and there isn't a requirement to do this in an offer letter or in any kind of written communication. It could be done verbally as well, if you are giving an offer of compensation and then letting people know what the pay scale is for that role. Both components have to be in there.
Okay, Annette, did that answer the question? You can let us know if you have a follow-up. I can read that off as well. Go ahead, Maria. Go ahead.
All right.
Yeah.
So moving to California, this is a new one that is also going to be requiring the pay scale to be put in the job posting. It is, and another component is it's going to be, so the current California law only requires the disclosure of a pay scale to an applicant and doesn't cover current employees. So the amended law will now apply it to current employees as well. So employees can request pay scale information in California if this law is signed by the governor. Okay, we also have Jersey City. Jersey City is another one that now requires the pay scale to be included on the job posting. And what must be provided is the minimum and maximum annual salary or hourly wage. And for a lot of these laws, the language that's used is that the range may extend from the lowest to highest salary the employer in good faith believes at the time of the posting it would pay for the advertised job, promotion, or transfer opportunity. And that's a common theme throughout these laws, to have this type of good faith requirements. And that really gets at looking at your practices as an organization and what you believe you're going to be paying for a position and how you evaluate candidates coming in and how you evaluate a role, and coming up with a scale that represents that range. Some laws have made it clear that if for some reason you have to go above or below that range because you have a stellar candidate who came in and you need to offer more than what the range you initially thought would apply was, then you can go above that range in those circumstances. I, of course, would recommend that you document the reasons for that. And there are pay equity considerations that will come into consideration, which we'll cover later as well. But a few thoughts on that. As long as it's a good faith belief of what you're going to be paying for the role at the time you're posting it, that's generally what these laws require. So New York State is going to, has another one of these laws that is currently pending governor action. It's been passed by the Senate and Assembly and is headed to the governor's desk. I think the expectation is that it will actually become law. So it's something to consider as we go through and consider New York City compliance as well.
Maria, I have a few questions here.
Yeah.
One from Danielle asked for clarity. Does this include staffing firms? I believe it does.
So for the New York state and cities, there is an exception in the law for temporary help firms. So if you qualify as a temporary help firm as is defined under the New York state law, then there's an exclusion from these laws because you're already required to provide certain wage information under the Wage Theft Prevention Act. So I would definitely look into that and make sure that whether you qualify as a temporary help firm for the New York laws.
Another question here from Camille. If the employee lives in Connecticut but works for a New York-based company, do we still follow Connecticut regs?
So this is an interesting question that comes up a lot. And it really you have to look at the requirements in the jurisdiction for and where the work is being performed. So if the work is being performed in Connecticut, but the company is based in New York, it would, let me take a look back. So I believe there's guidance on this in Connecticut, and I can look at that and then kind of circle back with the audience if you do that, Roger. I can circle back.
We can do it in our sort of follow-up email.
Perfect.
To the entire audience afterwards. We can include that in that message. We have one here from Hero Dukas asking if the pay range reflected on the job posting is reflected on the job posting, job description, and you pay above the maximum range. Is there any implication?
So Colorado says no. That's clear based on the Colorado guidance, where as long as you have a good faith basis for having that range you put on the job posting, and then you go above that range because let's say you have a stellar candidate who comes in who has much more experience than you were expecting, or they had a competing offer and you had to pay more for that person. The Colorado agency has said that's okay. The New York City agency has also said that's okay. The other jurisdictions, it's an open question. I would guess that they would take a similar approach, but that's not actually stated in any guidance.
And a question here from Jennifer, who asks, "This is the city of Jersey City the only New Jersey city that requires to post on an advertisement?"
Yes, that I know of. As of now, yes.
Okay. And it looks like we've got a three-parter here from Simone asking, if my office is in New York State but not New York City, and I'm posting for a position that will work in New York City, does this position have to include the salary range because the position will work in New York City?
The short answer is yes, and I'll get into that a bit more with the deep dive in New York City.
Okay, here's another. If the office is in New York City and I'm posting for a position that will work outside of New York City, Long Island, Westchester, does this position have to include the salary range because the position is being posted from New York City?
The focus of the law is where the work is being performed. So if it could be performed in New York City at the time you're posting the position, then you have to include the range. If it would not be performed, if it cannot be performed in New York City, then you do not need to include the compensation.
Okay, and lastly here, if the office is in New York City and the position is posted as a remote position, open to individuals who can work anywhere in the country, does the position have to include the salary range because the position is being posted from New York City?
If it's a remote position, yes, as long as you have, and the standard is if you have one employee within New York City and 4 employees nationwide, then yes, you would have to include the compensation information for any position that can be performed in New York City.
Okay.
So a very broad definition here that makes it like New York City law is applying everywhere, which is something that it's an interesting concept, but something that Colorado did, and now New York City is following.
Okay. Question from Lisa: if you benchmark a role, but you will likely only pay minimum to mid, can you not disclose the max range because it is highly unlikely?
So it should be in good faith what you're going to pay for the position. So if you don't think you're going, if in good faith, you will not hire at that high end of the range. Let's say your current employees within the role who have been in the role for 20 years, they're the only ones making that much, and you're not going to hire someone at that amount, then you would not need to disclose that. It's what you, in good faith, are going to be paying for the position for someone coming in.
Okay. Question from Becca: what is the guidance when there is a very wide range for the role? For instance, if a school is hiring teachers, the range can be anywhere from 60K to 120K. What is a reasonable range that is acceptable and compliant?
There's no specific guidance on how broad a range can be. It's really just focused on this good faith requirement. There is guidance that says you should really be trying to tailor it to the role that you are posting. So if there is any nuance within that range for the position, and there's a more narrow range that you can provide, I would recommend providing that more narrow range. But if it truly is a pretty broad range that you would consider paying someone within that role, and there's support for that within your organization, and you actually are hiring people at all levels of that range based on their experience, then that would be consistent with the law, because it's just a good faith requirement, requirement in the law.
Okay, I think that may answer 2 questions here. Greg, does that answer your question as well? You can let me know. Question from Mariah: when is the pay scale disclosure going into effect for New York State? I thought it was only going into effect in New York City in November.
Yep, New York City is November. New York State is being considered by the governor still. So the governor has to act on it and sign it. And then after signed by the governor, it will go into effect 270 days after then. So we have a bit more time on the New York State law, if it is in fact signed into law.
Okay, I think that answers Teresa's question as well. Question from Erin: is the requirement for total compensation or base salary? We have low base and a high variable quarterly bonus model.
So for New York City, it's base salary only that you have to disclose. It's base salary, and then any other forms of compensation do not need to be included in this. For Colorado, you would need to provide the base salary and then a general description of any other compensation you're providing. So if there is a bonus, you can simply say merit bonus or whatever benefits you're providing. And that could be a truly general description, like for benefits 401k or health benefits. It could be a general explanation there for Colorado.
Okay, and lastly, what is the guidance for nonprofit organizations that have specific budgeted salaries?
Then you would, if the question is if there's a budgeted salary, meaning a set amount instead of a range, then you can generally provide only that set amount instead of kind of making up a range. So if you are required to pay $20,000 for a role, then you can put in that rate as the only rate that you're providing. And that's the guidance in New York City states that, as well as Colorado.
All right, very good. One last one, and then we'll move along. If you offer more than the given range to a highly qualified candidate, do you then have to include that higher pay rate in future disclosures?
It depends on the circumstances. If you think after hiring this person that the candidates that you're getting from that first applicant pool, you weren't paying enough, for example. So if you had a set range and everybody who was coming in wanted higher than that, and you reassess your practices and now you want to hire at a higher rate, then yes. If that was a one-off situation where there was someone totally unexpected and you do not anticipate hiring at that rate again, then I think it's fine to keep the range the same. The caveat is I would make sure to document these circumstances so that you have those reasons for departing from the range. And if you find yourself having to go over the range more than once, then it might be a good indication that you do need to reassess your pay scales and your internal and external equity and take a look at how you're paying compared to the market. So it could be a good indication of where you are in the market as well.
All right, very good. All right.
All right.
We love getting all these questions. That's
yeah.
This is very, very interactive. That's always what we're going for.
Great.
All right.
All right, moving on. So another couple jurisdictions that require pay scale disclosure in job postings. So of course, New York City, which we've referenced. There's also Ithaca and Westchester County within New York. Now the requirements are largely similar for what must be disclosed. It's the minimum and maximum salary or hourly wage. And again, it includes this good faith requirement when including posting the wage range and determining what that range could be. For Washington State, the current law in Washington is just upon request of the applicant or the employee. However, there is a law that was just passed that will go into effect on January 1st of 2023 that will now require wage scale or salary range within the job posting. So that's another one to keep an eye out. That's coming out soon. And that one will require the wage scale or salary range and a general description of all benefits and other compensation to be offered to the hired applicant. All right, so let's do a deeper dive into New York City. So the New York City law makes it an unlawful discriminatory practice for an employer or an employment agency to advertise a job posting, promotion, or transfer opportunity without including the minimum and maximum salary for such position in the advertisement. So a key point about this is that it includes current positions as well. So it includes promotional postings that you might put out or transfer opportunities that you do post. So while there's a requirement to post it, I'll just note that the requirement does not, the requirement is not to post these positions if you weren't already doing that. So there's no requirement to post a promotional opportunity or post a transfer opportunity within New York City. However, if you do decide to post such positions, then you do need to include the salary range in those postings. The New York City law applies to employers with 4 or more employees, and it does not apply to job advertisements for temporary employment at a temporary help firm. And that's specific definitions for that under New York state law. And the New York City law references the state law requirements for temporary help firms. So after the New York City law was initially passed, there was an amendment. And the law was supposed to go into effect, and due to pushback from employers and others within the public, there was a push to get this pushback so that companies could comply. The amendment was passed, and it now means that the law is going to go into effect on November 1st of 2022. There were a few other changes that happened because of the amendment. So the amendment clarified that the law doesn't apply to positions that cannot or will not be performed, at least in part, in the city of New York. So it's a little phrased in the negative, but basically, if you have a position that could be performed in New York, whether it's remotely or they need to come in to the city for part of the time for coming into an office or anything like that, then the position would have to be posted. The position would have to include the salary range in the job posting. The amendment also clarified that the law applies to employees who are paid hourly as well as on a salary basis. So for hourly employees, you would include a range for the hourly compensation, or if there's a set rate that you would pay the employee, you would pay that set rate. You would include that set rate in the posting. The amendment also limited the availability of a private right of action to employees bringing claims against their current employers. So so applicants for a position cannot bring a private right of action in New York City. And that was really due to pushback from employers about a windfall of cases coming in from applicants applying to a bunch of different positions. So that provided a bit of relief to employers. Another part of the amendment is that it specified that there will be civil penalties only after a first violation. So the civil penalties will be $0 for a first violation, as long as the employer proves that it has cured the violation within 30 days. A caveat for this is that the law states that even though there won't be penalties for that first violation, the employer will be considered to have had a violation. So it doesn't directly state this in the law, but what we think is that this may increase the penalties then for a second violation, if there is a second violation under the penalty scheme in New York City. So the New York City Commission on Human Rights has also put out a fact sheet on the New York City law. The key takeaways from that fact sheet is that it includes 4 employees. The employee threshold is 4. So that's if the company has 4 employees, and the law applies if at least one of those employees works in New York City. Again, the law does not apply to temporary help firms, but employers that work with temporary help firms must disclose salary range in their postings. So there's no exemption for the employers that work with the temporary help firms. An advertisement is a written description of an available job, promotion, or transfer that is publicized to applicants regardless of format. So the guidance made clear that it's a very broad definition of the advertisement for a position. And as I mentioned before, there's no requirement to create advertisements for hire, but if you do choose to advertise, the advertisement must include the salary range. And for the salary range, it means the lowest and highest salary the employer in good faith believes it would pay to the successful applicant at the time of the posting. So this went to the points we were discussing earlier with you may have a good faith belief at the time of the posting for a certain salary range, and that could change depending on the candidates coming in. Another key takeaway from the guidance is that it covers posting for any remote work that could be performed in New York City. And here is the language from the guidance on that. And again, good faith requirements. It's the salary range that the employer believes at the time of the posting they're willing to pay, and the guidance goes through that. Another takeaway is that the salary range cannot be open-ended. So you can't say $15 per hour and up, or maximum $50,000 per year. If there's no flexibility in the salary, you can say the set rate. But if there is a range that you're willing to pay, you must include the bottom and the top of the range. As I noted earlier, salary or wage range doesn't include benefits, paid time off, overtime, bonuses, stock, or anything else that's not that base compensation. And of course, the employer could opt to disclose more information in the advertisement if it chooses to. There's just no requirement to do that. So if you wanted to include information on your 401k or that someone qualifies for a bonus, you can certainly do that, but there's no requirement. So potential exposure and penalties. A violation of the law will be treated similar to a discrimination claim under the city human rights law. But as I noted earlier, based on the amendment, civil penalties are $0 for the first violation. There is a private right of action limited to employees bringing claims against their current employers, so not applicants. And employees may sue for back pay, front pay, compensatory damages, punitive damages, and injunctive relief. Applicants or current employees can file a complaint with the New York City human rights law as well. So if it's filed with the Commission on Human Rights, then the commission can impose a civil penalty of not more than $125 or not more than $250,000 for a willful violation. The Commission on Human Rights can also order changes to certain job advertisement policies and practices as another means of redressing if there is a violation. Okay.
We've got some questions here.
Sure.
All right. Jennifer asks, says we have a step scale, which I will include in the offer letter, but I cannot advertise a range because we start with a base and then add variables, advanced degrees, experience. So will this be a problem? Is that clear, or do you want her to
I think I need more clarity on that. Yeah.
Jennifer, can you reword it and rephrase it and pop it in again? I'll move over to Jeff, who asks regarding New York City, parentheses, not an agency. If I reach out to someone on LinkedIn about a job opening, do I have to disclose a salary in my first communication?
Yes, if it's, so the New York City requirement is a written description of an available job, promotion, or transfer that is publicized to applicants, regardless of format. So if you're publicizing it, I suppose it would come down to whether that's considered a publication, if you're publicizing it to an applicant. I think on the safe side, I would, because you are publicizing it to a potential applicant. And so that would seem to fit into this definition, but yeah.
Okay, and question from Gail, any idea at this point what the penalty fees will be for New York?
So, yes. I believe we're going to get to that in a few minutes.
Okay,
so
cover that. I'll pop to another question from Allison. Okay. If we have locations in New York City, but we are based outside of New York City, do we also have to publish salaries for our non-New York City locations?
If the position can be performed in New York City, then yes. If you are posting positions that are not performed in New York City, so in any other state, or that cannot be performed remotely from New York City, then no.
Okay, one from Hero. If you create a job and you transfer an employee to that new job description, any implications for not advertising the position?
No, there's no requirement to advertise the position, but if you do decide to post the position in New York City, then you need to include the range.
Okay. A question from Lou, who's asking, is state law structured the same way? And though you might need to clarify a little bit which piece you're talking about so that she can address it.
We'll go through the New York state law as well, very quickly.
Okay. And yes, we've got a lot of questions here. Let's grab one more here from Jennifer asking, for example, a base is 60K, but if a person has masters and will receive 3K for each master's, a PhD will give an additional 5K experience. Additional experience is 200 per year of relative experience. I guess that's that was, I think, just an add-on to the other question. Yeah.
Yeah, I'll take a look at that question. I'm happy to discuss offline, but I think whatever your compensation structure is, I would recommend including that information within the posting. So if there are like set parameters that help you distinguish pay, if there's a set bump up in pay that you would get based on a certain degree or something like that, I think the safest option would be to include that information within the job posting and kind of provide that bump up that's potentially available. On the other hand, you could do a range and then specify that an applicant's position within the range might depend on various factors, including and then kind of list out the factors that might be considered in determining where you put somebody on the range. And I've drafted similar kind of posting language for certain employers. So that could be crafted in a way where you're specifying that the range takes into account various different factors that are considered, and that it'll depend on certain certifications you might have or other bump ups that are available.
Okay. Why don't we, we've got covering a lot of ground, we've got a lot of questions. We want to get to a few of our polling questions to just kind of see where our audience is and some of their plans. Walter, if you want to throw a few of those up here so we can see what kind of where folks are at. Okay, so first one, does your company have a plan for compliance in place yet for the New York City transparency law? And have you updated your job postings to comply with the law? So let's see where people are.
Okay, while we're waiting on that, I could quickly cover Ithaca and Westchester and those requirements. Okay, so Ithaca and Westchester largely track the New York City law and the requirements generally, which are including the minimum and maximum salary in the posting, promotion or transfer opportunity, that good faith requirement, and the exclusion of temporary help firms. There's a few differences. So Ithaca does not apply to an employer that employs fewer than employees whose standard work locations are in the city. So it has a more local focus, the Ithaca law. The Ithaca law also does not include the provisions added to the New York City laws amendment. So it doesn't have that 30-day cure opportunity where you don't get penalties and those other requirements from that law. The Ithaca law was effective as of September 1st of 2022. Some differences with Westchester are that The Westchester law includes some provisions from an earlier iteration of the New York City Amendment. So the New York City Amendment, there was a first iteration of the amendment that was being considered, and then it was amended and ultimately passed in a different form. The prior version of that New York City Amendment excluded help wanted signs or other similar communications from the law. So the Westchester law took that language and put it into the Westchester law. So under the Westchester law, help wanted signs are not considered a job posting under the law. The Westchester law also includes any employer who posts for positions that are required to be performed in whole or in part in Westchester County, whether from an office, in the field, or remotely. So this is different from the New York City requirement as well, in that jobs that are required to be performed in whole or in part in Westchester are included, but jobs that are not required to be performed in Westchester, so if they could be performed remotely from a different location, then they wouldn't be subject to the Westchester law. And this was something that was also being considered under the earlier iteration of the New York City Amendment that was ultimately not passed and went the other way. Another specification under the Westchester law is that it will become null and void on the day that statewide legislation goes into effect, if it does go into effect. So there's that provision in the Westchester law. And the Westchester law will become effective on November 6th of 2022.
All right.
Okay.
So we're
Great.
seems like people are partially there with the people doing better with their job postings than they are with their compliance plans.
Okay, great.
Actually,
Well, I hope this presentation gives you the push and guidance you need to get over the next hurdle.
Yeah. Walter, do we have our next polling question? Oh, yes. So here we are. Our kind of this kind of goes along with the back to the office. We're just here and about the general economy to see what people are planning to do with regard to all of these postings. All right. While we wait for that one, we can.
All right. I'll go into the overview of the New York State law. So again, this is pending governor action. It's not actually law yet, but given the likelihood that it will become law, I wanted to still cover it today so that you could kind of formulate your policies and job postings with this in mind. So general overview, it will require employers to disclose in a job posting the compensation or a range of compensation for the job promotion or transfer opportunity, as well as a job description for that position if a job description exists. The New York State law also specifies that advertisements for jobs that are paid on commission basis only will be compliant with the disclosure requirements if they disclose in writing in a general statement that compensation shall be paid on commission. So that would just be a general statement in the posting that says that. The New York State law follows how the New York City law is considering remote work, where it applies to job postings that can or will be performed, at least in part, in the state of New York. So any jobs, if they can be performed in New York, the state law would require you to include the compensation disclosure and job description disclosure in the posting. Under the New York law, there is no private right of action, and a person would file a complaint with the commissioner instead, the commissioner of labor, and go through that route, the agency route, instead of through a private right of action. The law also includes an explicit no retaliation provision, and there's a record keeping requirement where employers have to keep a history of compensation ranges and the job descriptions for any of the roles. And to the earlier question about penalties, under the New York state law, an employer would be subject to an order directing compliance. And it also may be civil penalties up to $1,000 for the first violation, $2,000 for the second violation, or $3,000 for a third or subsequent violation. There is rules and regulations that are expected to come out, as well as a public outreach campaign from the Department of Labor to get into more of the nitty-gritty of the requirements and have some guidance on how to implement these requirements. So that's expected to be forthcoming after the law goes into, after the law is ultimately becomes law. The law would become effective 270 days after enactment. So if the governor signs it, it would be 270 days after that. And I see the poll results in.
So those are pretty strong, strong economic numbers there. Hiring is still on the rise. All right, excellent.
Good to know.
Yeah, Walter,
All right.
the return to work. Wanted to kind of see where people are in terms of back to the office. Okay.
Yeah, and these are all important considerations as you think about pay transparency and where your workforce is located, and how you want to structure your job postings, particularly if you have employees in New York City or in Colorado, where all of your remote postings, if they can be performed in those jurisdictions, would need to include pay scale disclosure. So if you do have a big remote workforce, it's definitely something to consider.
All right. While we wait for that, continue.
Sure. I wanted to quickly go over the Colorado requirements. I went into them a bit when I started this presentation, but given kind of the nuances in Colorado and the broad implications, just wanted to mention those requirements for people who may have an employee within Colorado. So Colorado requires announcement of job opportunities made available to employees in Colorado. That's the promotional opportunity disclosure. And it also requires the disclosure of pay information for jobs in Colorado and remote jobs that could be performed in Colorado. And then there's a separate record retention requirement in Colorado as well.
All right. So people are definitely coming back, and I'm seeing that. I think we in our office are going to be back to at least 3 days in office as well. Mm-hmm. And speaking of in office, I try to give people recommendations. Everyone always asks about retention and everything else. So I'm going to pop into the chat window something that's helpful with getting people back in the office, and that is a good friend here, Lou Giordano of US Coffee. I don't know about you guys, but the snacks and coffee game in your office can be big attractions to keeping your employees engaged and in-house. So if you're having trouble getting people back to the office, reach out to Lou. Terrific person. Help you up your game. I don't know if this went to everyone here. I was trying to pop it into out to everyone. I don't know if that is if that's happening. Oh, there we go. Excellent, thank you. All right, you can moving along, and Walter, if you have another poll question, you can pop it up when appropriate.
Okay. So going into the Colorado requirements, Colorado requires for jobs in Colorado and remote jobs that could be performed in Colorado, you need to provide notice of promotional opportunities and compensation information disclosure in your job postings and in those notice of promotional opportunities. There are a couple exceptions for confidential searches or for temporary roles under 6 months. So I would take a look at those if those might apply. For your jobs that are outside of Colorado, if you are an employer with at least one Colorado employee, you're required to provide notice of promotional opportunities to your Colorado employees. If you are an employer with no one in Colorado, then this does not apply to you.
All right.
So for the compensation information disclosure, you need to disclose the hourly rate or salary compensation range, a general description of any other forms of compensation, and a general description of benefits. In the notice of the promotional opportunities, you need to provide the job title, the means by which the candidate may apply for the position, and when applicable, so if it's a promotional opportunity that could be performed in Colorado or a remote job that could be performed in Colorado, then compensation information must be included in that notice of promotional opportunity. Okay. Now, another brief note on California, because this is another big law that's coming down the pike. There is an amendment to the current California pay transparency law that is being sent to the governor. The California law would also require pay scale disclosure in job postings. It would apply to employers with 15 or more employees. And it specifies that if the company engages a third party to post, the company must provide pay scale information to third parties. There is also an addition of a requirement to provide pay scale disclosure to employees upon their request. And there's a separate retention requirement for maintaining records for the labor commissioner to determine whether there's a pattern of wage discrepancy, and the records have to be open to inspection by the labor commissioner. Okay. I wanted to quickly cover pay data reporting because it has some pretty broad implications coming up.
Okay. Before that, if I can
Yep.
make one more recommendation on the employee engagement side of things. Walter, if you can pop that up for people, and recommend a good friend, JJ Dunn of Benetix. For those of you who are focused on employee engagement and keeping your folks happy, sports tickets, theater tickets, and all other such things. JJ is a former coworker, great colleague. Please reach out to him if that's something that you can be helpful to you as well. Very good.
Okay, so pay data reporting. Another big push that we're seeing in being considered in these jurisdictions here that currently have laws, as well as other jurisdictions that are considering similar laws, is to require pay data reporting as kind of the next step in achieving pay equity. So, and just kind of frame this discussion a bit. With pay equity, the first step for pay equity was to really have these salary history band disclosure laws. And a lot of companies looked at that, and there were requirements with that. The next step seems to be these pay scale disclosure laws with requiring pay scale disclosure in job postings and requiring it to different applicants and employees. And the next kind of piece we're seeing of this pay equity initiatives is to have pay data reporting. And so California and Illinois currently have laws that that require pay data reporting to the agencies in those jurisdictions. So California's pay data report, this is now the second year for California's report collections. Reports were due on April 1st, and employers who are subject to EEO-1 filing obligations with 100 employees and any employees working in or reporting to California establishments are required to file this report. Employers have to report their establishment, job categories, race, ethnicity, sex, state, and hours worked, using a specific reporting form. There are some key differences, though, between EEO-1 reporting and the reporting here. The information that must be reported is a bit different. So in the EEO-1 report, there's a different information that must be provided, whereas for this California reporting, you look at W-2 box 5. You look at the hours paid to employees, even if not worked. So for the California requirement, it includes paid time off. And there's separate reports for each legal entity. And I put a link here for more information on the California pay data reporting requirements.
I have a couple of quick questions here. Andrew asks, my company has employees in many states. If we include wage range for each job we post, are there any states this will not satisfy? Understanding that Colorado also requires benefits to be posted.
So that's, companies are considering that approach for sure. I mean, the administrative burden of trying to follow these laws and comply with them is, it's a lot. So I think a lot of companies are considering potentially doing that and just having across the board pay transparency. I would make sure, if you want to do that approach, that whatever job posting language you are including meets all the nuances of the different laws. So you're still going to have to do some state-by-state analysis to make sure that the posting that you have complies with the different requirements. So you might want to include all compensation information if you need to comply with Colorado in your New York City postings as well, to make sure it complies with everything. So I would just make sure to do that analysis to make sure you're compliant with all the different laws. And I would also kind of make sure that you have a system in place for if applicants or employees request the information, or the other states that require affirmative disclosure at some point during the application process or during an employee's employment. So if you have to provide notice of wage range disclosure when an employee transfers to a new position, you're still going to have a system in place for making sure that you meet those requirements. So just a couple caveats, but I think that is an approach that I'm seeing a lot of companies consider now.
Yeah, we've got about just a little under 15 minutes, and so we want to see what we can cover in that remaining time. So if you want to bounce around a little bit, Maria, I don't know how far down we are, but whatever you consider to be the most critical, we can get in for folks.
All right. So moving to California pay data reporting, there is that amendment that I discussed earlier that is pending governor action. If that law goes into effect, it will change the pay data reporting requirements a bit and require companies to also report mean and median hourly rate information to the California agency. So something to keep in mind as this amendment potentially goes into effect. Another quick note on pay data reporting in Illinois. This is another state that currently has pay data reporting requirements. It applies for private businesses with more than 100 employees in the state of Illinois who are required to submit an EEO-1 report. So employers in Illinois have to apply for an equal pay registration certification now. The businesses provide contact information to the agency, and then notices will be sent to employers, letting them know when they have to submit this application. The due date will be every other year, where an employer has to submit this. And this is just an overview of the different application components. So employers will submit their EEO1 report, and then there's an employee list requirement where you go into the more specific employee level data within the form. There is also an equal pay compliance statement where you need to state or certify compliance with different equal pay laws. You have to certify that there's a lack of wage disparity within your organization and that any disparities have been addressed. So it's an important piece of this where you're certifying to certain elements of pay equity within your organization. So definitely something to keep in mind. And then a quick note on the accessibility of this data that companies are submitting. I know it's a concern that if you're submitting all this information to the organization, how they're going to use it. So the data that's submitted is confidential. It's not subject to a FOIA request. However, employees can request anonymized data regarding their compensation, regarding the compensation for others within their same job classification or title. And the data can be shared with the IDHR or the Office of Attorney General. So there is that added piece of potential enforcement if there are issues. And penalties, so there's potential fines up to fines of $10,000. And there's also penalties for falsification or misrepresentation of data. Okay, so I wanted to talk about the impact of pay equity with all of these laws. So as Roger referenced in the beginning, I mean, the current climate is unique and presents its challenges. A lot of people have remote workforces now where they didn't in the past. A lot of companies have are hiring at a much faster rate, and it seems like that's the case, that a lot of you all are hiring now. So there's a note here that sweeping changes to your workforce can easily throw off pay equity. So if you're hiring and you need to hire at a much higher rate now, given the market, than what you were hiring for in the past, that could certainly skew your pay equity within the organization and create issues for your current employees and the equity within those roles at your organization. There are also efforts going on to replace talent or retain talent that can impact pay equity, such as offering sign-on or retention bonuses. That might be a good way to not skew your equity with both base compensation by offering other forms of compensation that might help to kind of keep the equity in check. And there's a unique situation now where tenure and an employee's time with the company may actually have a negative effect on their pay, given the hiring rates that are going on and having to pay higher amounts for people coming in. There's also the considerations of remote work and geographic differentials. So a question I get asked a lot is, okay, we're hiring for remote work across the nation. We could hire anybody, but what we actually pay that person depends on where they sit and their geography and the rates we're willing to pay within that geography. So there's certain ways that you can structure your job postings to take that into account. And it's certainly factors that you should be considering as you're deciding what an appropriate wage range should be, and how you're doing your job postings and which laws apply. And these pay transparency laws, they really highlight any differentials within pay equity. I hear a lot of concerns from employers about, okay, if I post this position at this rate, my current employees are going to raise concerns with this. They're going to say, why am I not being paid at the high end of the range? So it's important to to consider those impacts within your organization and how this current climate and the potential differences in wages are going to impact your organization and your current employees. So what should companies do now to try to comply and develop a compliance strategy? So I think the first step is really considering what your organizational goals are for transparency. Who do you want to share information with? When do you want to share it? Do you want to consider having, similar to the question before, do you want to have just an overall pay transparent system and just post all pay ranges in all job postings to ease that administrative burden and to really have a culture of transparency instead? It's also important to consider the states where you're located and other jurisdictions. Are you in a jurisdiction like Colorado or New York City where your remote postings are certainly impacted? Another thing to consider as you're developing these strategies and developing compliance systems is to determine if you have pay ranges in place currently. If you don't, do you need to create pay ranges for your current employees and for different levels or depending on position? Or do you need more tailored pay ranges so you're not posting a range that is extremely broad and goes beyond what you would actually pay for someone in a role that you're considering? And then what other relevant considerations are unique to your business? Are there certain aspects of your business that you want to keep more confidential in compensation for strategic reasons? Maybe there's certain areas of your business where there's more competition and with competitors in the salary that you're offering. Maybe you choose to have a more broader approach for pay transparency within certain aspects of your organization and keep a more targeted approach for other aspects of your business where more confidentiality is necessary to have a business advantage. So these are all considerations that should be coming into play as you consider compliance here. And another kind of key point is to make sure that your hiring managers, talent acquisition professionals, your all human resources employees are trained on the requirements of the law. So a suggestion might be to have talking points for your HR employees so they know how to respond, or talking points for your supervisors who might get questions from employees on what their pay range is, and they need to know how to respond to those inquiries. You might have FAQs for your supervisors or other employees to give them helpful answers on what must be provided, who to direct information to, who to reach in human resources, and other key information for them to appropriately respond if they get an inquiry on this. You could also create templates for responding to requests for pay disclosure. Maybe every time you have a pay disclosure request from an employee, you have a template that you can use to formally respond. So there's the process in place for that. You may also have a template for proactive disclosures. If you choose to do a written disclosure, for example, in Connecticut, at the time you're offering employment, then perhaps create a template for that where you'll disclose the required information to make sure that that's part of your hiring process and part of the process that you go through when hiring. And then there's, of course, developing job posting language based on your transparency strategy. Do you want to have a broader, transparent approach? Do you want to develop your job posting language to comply with all of the laws to the best you can? Do you want to include information on the factors that are going to be considered in determining where someone's pay falls on this pay range? Are there certain geographic implications that should be considered that you want to reference? I think these are all considerations that you may want to have as you're developing that language. And very quickly, given these equity concerns, it's always a good idea to do a proactive pay analysis, and that analysis be be prepared underprivileged with an attorney. You could be strategic in keeping in mind the various laws. You can look at the relevant factors that are impacting pay. You can look at, do you have a compensation structure that allows for appropriate comparison group? And doing this type of pay analysis really highlights your systems and helps you determine how your current pay practices are working for you, whether there are disparities that you need to address as you roll out more pay transparency laws and potential concerns from your current employees. And then just making sure that you have, and I cut ahead, but making sure you have a system in place for continually evaluating compensation on a going forward basis, because these laws are certainly here to stay. So,
yeah. Well, Maria,
that,
thank you so much. You'll see I also popped your contact information into the chat window. We are going to be sending out a follow-up email, so maybe some of the, and you'll be able to reach out directly to Maria with your individual questions, anything that we did not get to. And also, if just for further presentations, if anyone did not receive their invite directly from us, maybe you had it forwarded to from someone else, and you'd like to be a part of the HR Roundtable going forward and receive our invitations, I popped my information there into the chat window. Walter, can you share that? Just reach out to me and let me know that you want to be on our regular distribution list, and we will make sure that you get invitations to the HR Roundtable going forward. The slides and video will be made available to everyone. And so it's September, back to school. We've got we gave you a good dose of useful information here. I hope that everybody found it to be useful. And Maria, thank you for a tremendous job. It was a lot to squeeze in a short window. So greatly appreciated. Thank you all, and we will be in touch. Everyone have a terrific day. And Walter, take us out.